Good morning. Right from the beginning, the Kerala High Court and Allahabad High Court always interpret the law in favor of the litigant. A very fantastic question was recently decided by Allahabad High Court. The question was whether first wife can file Section 11 petition under Hindu Marriage Act to declare her husband second marriage was null and void. In the year 1960, Madras High Court has held that by interpreting the clear provisions of Section 11 Hindu Marriage Act, that either party thereto was restricted to only the persons between whose marriage was solemnized. Therefore, the wife was left to file suit for declaration instead of approaching Hindu Marriage Act Section 11 petition. So this judgment was time to time filed for so many cases. 1960 continuously it is being followed. There is one Supreme Court judgment at paragraph 21. 1 minute. That I did not notice. What paragraph 21 says. Issue evolved in Lakshmi Memmal case, AR 1960 Madras, has consistently followed pre-enactment of the Family Courts Act 1980. Thereafter, it took a different view and held that the second wife can also file a case under Section 11 of the Hindu Marriage Act. Even a third party to the marriage can also approach the court for declaring marriage as illegal and void when they are affected with marriage until it is banned by statute. So this is what Balram Yadav versus Pulayamma Yadav. This is Supreme Court judgment. See, the question is very interesting. I will read. So many things you can understand. Therefore, I am reading. The Pratima Singh is the respondent in the appeal, against family court appeal. She married Raghavendra Singh and there was a dispute. So Raghavendra Singh filed a case for divorce, and here the wife filed counter wherein she claimed Section 9 Hindu Marriage Act for restitution of conjugal rights. The husband application was dismissed and the wife restitution was ordered. In meantime, the husband Raghavendra Singh married Garima Singh and two children were born, and they have registered a will. Her father-in-law will and bequeathed the property. That was challenged, and subsequently she filed a complaint under 494, 495 and 496 also. That is still pending. Then some suit was filed challenging the will. Then she filed a matrimonial case under Section 11 of the Hindu Marriage Act under Family Court Act. The Family Court allowed her for the maintainability of the petition. Then they went to High Court. High Court has categorically held. Several aspects has been discussed. So many dictionary words, so many judgments about the words used for interpretation. They say particularly the word either, how to discuss the term either was interpreted. They say when examining the surrounding text and context, it becomes evident that the intention is to give full effect to the and interpret the act purposefully. That was the law of interpretation. You have to understand it. Finally, they held that first wife application under 11 was maintainable, and lower court must go with the trial. And they say the meaning of the phrase either party thereto is considered to be unclear or ambiguous, the principle of beneficial construction should be applied to determine its intent. There is no justification for interpreting section 11 in a way that restricts its scope or narrows down its meaning. So, a purpose of granting degree of nullity is to identify flaws in the marriage and subsequently declare as it was. Therefore, they held it. Kindly go through the judgment. Those who are really interested to understand the law of interpretation, and particularly this area of, is most, you can even file a project, or even you can file a dissertation on this subject. I hope you understand my purpose for reading this judgment. This is AR 2023, Allahabad 197, AR 2023, Allahabad 197, Garima Singh versus Pratima Singh and another. In between, the husband died. That is also most important thing. Then during the pendency of that OP, husband died. So the person was continued for maintenance. Best wishes.